Hi, Lee. How are
Hi
you?
there.
Ian will be on shortly.
Okay, how you doing tonight?
Good.
Hey Lee, how are you?
How are you tonight?
Good. I have bad audio here. Can
Can
you
you
hear
hear
me?
me?
Oh
Can you
yeah, yeah.
can
Got
you
it.
hear me
Yep.
okay?
Yep, got it. How are you doing?
I'm doing great. Doing
Good,
great.
good.
Thanks for having me.
Yeah, no problem. Just give it a few minutes here, let everybody join up, like 2, 3 minutes.
No problem. I took some notes on your questions, so I have a lot that I can talk about with those four. So wherever you want to go, I'm pretty good.
Okay, sounds good.
You're all set, Ian.
Okay, thank you.
Okay. Enjoy your meeting.
Thank you. All right, Lee, you good on your end?
I'm good.
Cool. Okay. So the way it will work, I'll just kind of introduce you here, and then there'll be some live people that in the chat as they come in, and they might have questions throughout Q&A. And then SJREIA will end up cutting this up and sending it out to all their members and stuff like that. So
Awesome.
yeah, it's pretty straightforward. Honestly, it's pretty low key. So yeah, I'll introduce you. We'll go from there.
Sounds like a plan.
Okay, perfect. Okay, so we'll start here. I'd like to thank SJREIA for having us again, allowing us to utilize their resources to put information out to investors in our space in the real estate market. I think it's a great platform. It's the largest real estate investment um, organization in South Jersey. And today we are joined with a very interesting individual because anybody that's in real estate investing will bump into a bankruptcy on one side or the other at some point in their investing career. And so I was recommended to have Lee Perlman join us, highly recommended actually. So I didn't really know any bankruptcy attorneys, and Lee came as I said, highly recommended. He is a leading bankruptcy attorney, founder of his own law firm. Lee M. Perlman serves the clients in Cherry Hill, New Jersey. You assist clients in bankruptcies, obviously, Chapter 7, Chapter 13, debt financing, restructuring, student loan issues, foreclosure defense, business reorganization, fair debt collection practices, fair credit reporting issues, lemon law. Now, Dean, you were a Dean's List graduate at American University, majored in government and criminal justice, and got your Bachelor of Arts in 1990. What got you into becoming a bankruptcy attorney? Like, what triggered you and goes, "Hey, that's for me."
Yeah, it's a good question. I'm practicing on my own 30 years. So I just really liked the area because you can get a client an immediate result. After dabbling a little bit when I began handling a divorce here, a personal injury case, real estate transactions, I just really liked reducing people's stress and giving them immediate results, stopping a sheriff's sale, stopping a wage garnishment, making sure that the collection call doesn't come through during dinner or on the way to soccer practice for a parent, and it's been history ever since.
Okay, that makes sense. Just kind of steered you in that direction, and you found a liking to it. Why don't we jump into some questions? I watched that video of yours with the myths about bankruptcy because, quite frankly, from where most people stand, they don't know much about it, and it's really a good thing to be educated on. I'm personally here to find out more because I'm RN from a lending perspective. It's on the other side. Typically, people file bankruptcy, and then I don't really know what happens on that side of it. Um, so let's cover some just basic questions, I think. When people go to file bankruptcy or they're thinking about it and they have that overwhelming burden, I'm sure, of financial issues surrounding them. Do they lose everything in a bankruptcy or how does that actually go?
Yeah. So what I would say is it's really going to depend on the chapter. But if we talk about the consumer side, and you own real estate, most of the time, at least today, everybody's property has equity. So it's unusual to file a Chapter 7 where no one's paid back because there are limitations about how much equity you can have in a Chapter 7. So most of the time, if you own real estate, you're filing a Chapter 13 so that the property isn't impacted. Maybe you're paying back some creditors because the property has equity, or maybe you're paying back mortgage arrears or reorganizing under Chapter 13 because you needed to stop a foreclosure. We can talk a little later on about Chapter 11s and how they impact real estate investors, but on the consumer side, that's kind of a broad overview of where people land.
Okay, that makes sense. So now I'll ask from like a personal standpoint. I typically have, not typically, but it comes up certainly. Like if a client, they take out a loan, they get behind on the loan, and then we get documents, hey, they've been served, or they file bankruptcy, and we go, you know, we usually, I mean, always, we eventually get our payback on our end. So
Yeah.
what's usually occurring? Like, what advice are they receiving from the bankruptcy attorney on their end normally, and what advice should they try to like steer away from? Hey, this is a good idea, because usually from like the lender's perspective, we're just like, dude, don't file bankruptcy. That's what we
Yeah.
say. But I don't know. Is that
Well,
yeah?
I mean, for the bankruptcy for the real estate investor, I guess that's what you're asking, right? From their perspective,
Yes, yes.
yeah, yeah. So from their perspective, look, the real estate investor who might need to file. I mean, look, I'll talk about a case we just had a couple of months ago. They didn't end up filing, but they were an LLC. They were two real estate investors, not sophisticated investors because they didn't have a lot of other projects, and they got a little ahead of themselves. The valuation on the LLC, I think it was a 5 or 6 unit development in Philly, didn't work out the way they wanted. They had some problems with some subs, and all of a sudden they ran out of money and couldn't get the project complete. They really weren't a candidate for a bankruptcy. But what we tried to do in that particular case was kind of do a workout and go back to the lender so they might take a little less than what's owed. But remember, if there is equity and you are a real estate investor, there's some pretty powerful things that you can do in a bankruptcy when it makes sense. You can reduce principal, you can extend terms, and more importantly, in a Chapter 11 context, you don't have to pay back interest on arrears in a Chapter 11. So that's huge. Over the course of a plan, you might save a significant amount of money if you put a plan together that doesn't necessarily have to pay back interest.
That's interesting. I didn't know that. I definitely I didn't know that. From a lender's perspective, from our side, then how do we best work
Yeah.
with somebody? what's the best thing we can do instead of getting like stonewalled or into a
Yeah,
situation
I
that's not
mean,
working?
the I mean, if you have a significant stake, in a piece of real estate, and your security interest was recorded in an appropriate amount of time, and you protected yourself, you want to get experienced bankruptcy counsel on the lender side. That's not me. That's not my space. I mean, I see it on the other side, because you don't want to blow a deadline. Like, for instance, if it's a tenant occupied property, remember in Chapter 11, some of those leases can be modified. So if you can modify a lease in a Chapter 11 and the owner of the property, that can be huge. Your rights to be impacted. So you want to meet with an attorney to make sure that if you have a defense to that and that lease is going to get modified, they're not going to do it in a way that's going to hurt you.
Gotcha. Okay. Now your internet's cutting out a little, Lee. I don't know if you I don't know if you have like on a Wi-Fi or not, but it was just cutting out a little bit. I did hear what you
Okay,
said
sorry.
though, but yeah.
Sorry. Yeah,
No,
yeah,
that's okay. We have some questions coming in. So first
sure.
one says, as investors, quote unquote landlords, we have tenants filing for bankruptcy and owners who are helpless in collecting rent. Uh, please ask questions around that. So I guess that was kind of, how do the owners collect rent? So do tenants when they file a bankruptcy, do they not have to pay rent? I'm not actually sure about that. Is that
Yeah.
correct?
So in the consumer context, if somebody's filing a Chapter 13 and they're a landlord and they're going to reorganize on the consumer side, um, they have to do a number of things on the bankruptcy side. For instance, in a consumer setting, if somebody is in a lease, they have to, you're a landlord, you want to file a motion for relief from stay immediately if they're not resuming their regular monthly rent. Second thing you want to do in a Chapter 13 is look to see if they are paying the trustee and if those arrears are being cured in a reasonable amount of time. If you don't understand how Chapter 13 works and you're a landlord and you don't have a bankruptcy attorney, maybe the attorney is the debtor's attorney is going to schedule all those arrears over 60 months. There's case law that says rental arrears have to be paid over a shorter period of time, 10, 12, 18 months. But look, sometimes debtors lawyers will file maybe thinking that the attorney on the other side doesn't understand how bankruptcy works. They're an individual landlord. They're not sophisticated. They're not an institutional landlord. You want to file a proof of claim, which is a document you file with the court, and there's a deadline to do it to make sure that your arrears are being captured appropriately and that the plan that the debtor files matches up with that. Also, let's say that you file a Chapter 13 bankruptcy and you're the landlord and the lease expires in 6 months. A lot of people don't realize you don't have to renew that. You're not obligated to renew that. You could take payments for 6 months, and then you have an opportunity in the bankruptcy to give the tenant a notice of non-renewal.
That's one thing I can definitely say about a bankruptcy situation is to not do this on your own. You should have an attorney. I don't think there's a question about it because nobody would know how to
Absolutely.
navigate this. Yeah.
Yeah, it's really you don't want to get caught in a situation where you have a sophisticated attorney or maybe a filer who's filed more than once. Nothing worse than being a frustrated landlord. And look, I've represented creditor landlords before, so I've done that before from time to time, and it's highly frustrating. But the best thing that you can do is speak to a bankruptcy attorney, get a copy of the plan, and then you can look to see whether disclosures are appropriate. Maybe you want to hop on the 341, which is the first hearing the debtor has to find out if they listed all their income, they disclosed their assets. Is the plan feasible? If the debtor has a trustee payment of $1,500, which is curing rental arrears of $10,000 or $15,000, and his budget doesn't provide for that, that's the basis for an objection. And you can help do the trustee's work to say, hey, this is not feasible. Chapter 13, the standard is all about feasibility.
Understood. Okay. Let's take one step back, because I think you were going to talk about this before. Somebody's asking, can you briefly describe the difference between a chapter 7, 11, and 13, just so everybody's clear?
Yeah. So let me take 2 steps back and explain. Happy to do that. Great question. So a chapter 7 and a chapter 13 are mainly on the consumer side. So chapter 7s typically are in situations where either A, the client is earning under a certain amount of income. So for a single individual in the state of New Jersey, there's an income limitation. Median income in the state of New Jersey is about 80 and change for a household of 1. Let's just make it simple. If you're earning over that, there's some exceptions. In most cases, you're automatically disqualified from a 7 because it's means test limitation. Your income is too high. That's the first thing. Also, let's talk about real estate. In the context of a chapter 7, you can't have too much equity in your property. There's some, but if we take it, cost of sale and taxes, give or take, you can't have much more than $35,000 worth of equity in your homestead, in your house. Everyone and their grandmother has that much equity now. So I began by saying, in most cases, if you own real estate, almost everyone has $30,000 worth of equity. So for that reason alone, you'd be disqualified. If you go to a bankruptcy lawyer and they don't understand that, run for the hills, because what's going to happen is they're going to sell the property. I've tried to save cases like that where people have gone to bankruptcy attorneys who maybe dabble or don't do it regularly. You must concentrate in bankruptcy if you're going to go to a bankruptcy attorney. You can't be a generalist. So those are some of the differences between 7 and 13. In a 13, you can file a bankruptcy right before a landlord-tenant hearing. If the landlord has gotten a judgment in landlord-tenant court, you can't file bankruptcy and cure the arrears. It's too late. It has to be prior to that time. In the context of real estate, you must file before the sheriff's sale. And I file bankruptcies 1-2 minutes before sheriff's sales. I mean, we're used to dealing with deadlines. Now, in a chapter 13, if you file after the sheriff's sale and you have that right of redemption, which everybody knows you can extend the period of time for 10 days. Interestingly enough, if you're the homeowner and you file chapter 13, and you file within the 10 days, you can get an additional 60 days. Maybe you're working to get the financing done. Maybe you're going to get a sale plan completed. But you can file and use that redemption period to be extended in connection with a 13. So those are some of the differences between a 7 and a 13. Also, in a 13 versus a 7, you have to pass what I call the disposable income test. So if you're bringing in $1,500 a month and your expenses are $1,500 a month, you don't have any equity in your property, right? And you're under a certain level of income, hey, that's a chapter 7. The flip side is, if you have equity and you have money left over at the end of the month, then you're probably going to have to be in a chapter 13, and you're going to have to pay a dividend to your creditors. So those are some of the main differences between 7 and 13. And by the way, I have clients in chapter 13 that need to reorganize mortgage or rental arrears who earn, $30,000 a year. And I have clients now that earn $800,000 a year, and everybody in between. Financial distress and financial illiteracy touches people at all levels. And it does not discriminate, in my opinion. So that's 7 versus 13. Chapter 11 is really for a business. So if you have an LLC, you can't file a 13. Only an individual can. If you have debts over a certain amount, you can't file a chapter 13. Here's another example. Am I going too fast? Am I doing all right?
No, you're good. You're good. Perfect.
Yeah.
Yep.
I mean, if you have unsecured debt, doctor and hospital bills, credit cards, merchant servicing loans, payday loans, personal loans, if all your debt exceeds $460,000, you are over the jurisdictional limit to file chapter 13. You are automatically in a chapter 11 context. Chapter 7, no limitation on debt, but remember, you can't have too much income and you can't have too much equity in your house. So if I see somebody with debt over that amount, they're going to have to be in a chapter 11, which is a little bit more complicated, a little bit more expensive, and certainly more involved, because you have to be able to show a feasible plan.
Okay. So when you're dealing with clients that typically don't, they're out of money, how do they afford an attorney? I'm just sheer curiosity.
So you know, Ian, that's the question I get asked when I'm at a party or someone asks me what I do all the
Okay.
time.
I
If
know.
we
I
had a
know.
ranking, that's the number. No, how do you get paid? Yeah.
Yeah. Yeah.
So I mean, here's the short answer, and I'm practicing 30 years. In most cases, if people are facing a sheriff's sale, a wage garnishment, a bank levy, and I'm going to tell them they're going to be able to preserve assets that may have equity, they figure out a way to get me paid. Look, not in all cases, or I'd be retired in Barbados, right?
Mhm.
Certain people can't afford bankruptcy because it's not their space. Either they save the money, it's under the mattress, they realize they're going to have to set some money aside for a bankruptcy lawyer, or I can be paid by a third party. Perfectly appropriate. I can be paid by a family member, friend, or relative, and they can pay counsel fees. So between some of those strategies, people figure out a way to get me paid. You know, that's what I do. What I do. We're fortunately here to help.
Okay. Perfect. That's I just had to figure out there's got to be a way to do
No,
that.
great, common question.
Good, cool. Okay, so I don't know if you want to answer this, but another question just came in. What are typical fees for your services, especially quick tenant? Okay, so it seems if I'm following the chat right, Anu, I'm not sure how to pronounce your name. If I'm following the chat correctly, it seems like you have a tenant situation. You're probably a landlord, and you're trying to figure out how to work in this scenario where your tenant probably filed bankruptcy. So it looks like they're trying to look to you, Lee, and say, hey,
Yeah,
what are your typical fees? And especially in a quick tenant bankruptcy
yeah.
case.
I've been stepping away from doing both sides of the aisle just because, quite frankly, it represents conflicts of interest. So I have colleagues that'll do that. But look, generally, if you're going to hire, the landlord's going to hire you or a law firm when the tenant files. You know, you have to file a proof of claim. You want to file a motion for relief from the stay. You have to enter an appearance in the case. I mean, somewhere between 1,500 and 2,500, depending on what you're doing. And I don't think that a lawyer, again, in my opinion, a lawyer should go ahead and bill you hourly for something like that. Most of the time, you might be able to figure out a fixed flat fee. Maybe they'll bill you hourly. It depends on their fee structure. But in that range, it shouldn't be that expensive. But believe me, it's money well spent. We just spoke about looking at the petition to see what those strategies are. Maybe you can reject the executory contract. Maybe the plan's not feasible. Maybe you can file a motion to dismiss the case because the debtor filed in bad faith. A lot of different ways that you can look at a case. It probably will be money well spent.
Okay, jumping topics a little bit to other clients that would be in here as investors looking to, one of the ways that people purchase properties is through that are in bankruptcy, right? So what is the best way? I'm not sure how to phrase it. Like, because everybody in here is thinking, how do I get a deal out of bankruptcy so I can get a steal of a deal? But on your end, you're saying, hey, I'm protecting my client, to make sure they get the most they can. So what's the best way an investor could approach your client and make sense of a transaction in some capacity?
Yeah, I think that it's a great question. I think it's going to depend on the individual situation, and I think you're better in most cases seeing if you can approach a homeowner or an owner of the real estate, whether it's on the commercial side before they're in bankruptcy, because once they file. The debtor is going to lose control of the transaction. So if it's a situation where the trustee's in control and they're going to sell the asset, I mean, you can contact the trustee, but you're just going to get in line in connection with whether that's going to be valuable. To reach a debtor before they file and see if you can come up with a feasible plan so they can avoid bankruptcy, avoid a short sale. I think there's value there. And look, you guys don't have the same limitations on contacting individuals who are in distress. I have the rules of professional conduct. I can't do that without certain disclaimers, and that's not how I practice. I'm mainly referral based, but you guys can. You can reach out to people without that limitation.
Does it make sense for, so in the investment space, you're always looking for avenues of where, I started in 2008. I used to wholesale properties, which is, I'm not sure if you're familiar with that,
Yeah,
but I was always looking for, you're actually not looking for properties. The old saying is you're actually looking for problems attached to properties.
yeah.
So does it make sense for people to reach out to bankruptcy attorneys to say, hey, do you have any clients that are looking to move property, or is that
I mean, I don't think it hurts.
okay?
I mean, I think that you have to give some thought to how you're going to distinguish yourself. And look, I don't have an answer there, and it's more a business relation, business development. So, I get those calls a lot. And what I really want to know is, well, how are you going to be different from some of those other people that have reached out to me? And how's my client going to benefit? So, kind of it's a push pull, right? You guys are coming at it. You guys want deals, right? People are vulnerable. I mean, if I'm going to be contacted by an investor, and I'm going to go to a client and say, look, here's a non-bankruptcy solution for you. I have a fiduciary duty to let them know whether it's going to be workable, and not just to give them the only deal that might come down the pike, right? So I have to be objective, and I have the rules of professional conduct require that I'm giving them advice that's going to be in their best interest. So it can be very tricky, but at the same time, if it's the 11th hour and the bankruptcy doesn't look feasible, and we can't show a profit and loss or a sale plan or a feasible plan to be able to cure arrears, maybe the investor works. Let's say, for instance, someone's coming to me and they have $300,000-$400,000 in mortgage arrears, and we run the numbers. That plan over 5 years, in most cases, is not going to work. It's just not feasible.
That makes sense. Now, do you find with most of your clients that they do have real estate? Is that super common or not?
So pretty common.
Okay.
I mean, look, more people own real estate that don't, and and it's probably the subject of a new video, but many people get involved in real estate, at least on the consumer side, who, in my opinion, don't belong there or aren't ready. But that's the way of America. I mean, I have a client now, and I always like to know my client's backstory. Oh, you bought a property. Just had a new client last month. They bought a property less than a year ago. The property has not appreciated a lot, strangely enough, where it's located. I said, what was the problem? Well, we bought the property. There was a problem with the sewer. I didn't have any resources. I lost my overtime. And it becomes this cascading effect where they started to use their credit card to fix things in the house they couldn't afford. Before they know it, they lost their overtime. They couldn't make the monthly payments. So in that particular case, we were going to file a 7 and surrender the property. And they had a second. So second mortgages are much more likely to come after somebody for a deficiency. In a first mortgage environment, they don't. But a private lender or a second mortgage, they're going to pursue a deficiency. And that's why sometimes a Chapter 7, at least in that case, could be valuable or important.
That's interesting. Anybody else that's in the room that came in late, you can post any questions you have in the chat. Should be on the bottom of your screen. And as we kind of wrap up over the next 5 minutes, if anybody has anything that comes in. So Lee, what do you want to leave people with? Is there any kind of like general summary of like
Yeah, I mean, I would say, look, if you're an investor and you sense there's going to be bankruptcy, consult with a bankruptcy attorney. Anybody can reach out to me. I'm at newjerseybankruptcy.com. That's my website. I'm always happy to give a referral. I know most of the people in the bankruptcy space in South Jersey and doing this 30 years, but don't wait till it's too late. I always say that these deadlines are stressful for both lawyer and for clients, and understand that, bankruptcy can be a powerful tool. So when you see someone file, many times, they might have a sale plan together. They can sell, but people, at least on the consumer side and sometimes on the business side, they wait too long. They wait too long, and then they don't have a strategy and they don't have a plan, because everybody thinks that every other single option is going to work out, when many times it doesn't.
Okay, that's interesting. I guess you run into a lot of denial into the last minute kind of thing?
A lot of denial, a lot of conversations where we end, I've given them options, and I'll end with something like, well, if you're not going to do this, what are you going to do? I mean, respectfully, if you didn't like my advice or you don't think we're going to work well together, I'm not offended. I'm a big boy, but is it another attorney? No. Well, if you don't file bankruptcy to sell the property, you're going to lose your equity. Yeah. I mean, people really think, many people, not always, they're going to wait to the last minute. The rich uncle's going to come in. I'm going to get the inheritance that I've been waiting on from the surrogate for the last 3 years. It's remarkable what people will cling to, and that's human nature.
Yeah, that's interesting. I've seen, I mean, I've experienced, people in that state, typically when they're like in a state of foreclosure, it's just, the reality just shifts. There's a block that just goes up. So I'm sure you experience that frequently. And at some point, you have to kind of face it.
And the other issue too is there's just a lot of misunderstanding about bankruptcy. People don't understand that it's not going to impact their credit in the way they think, when most of the time their credit has already been impacted. If they're going to file a Chapter 13 and reorganize, their credit in many cases is going to get better. So there's just these mental blocks based on a lack of education, because bankruptcy is so unusual, not just to consumers, but to regular lawyers. Anytime I say bankruptcy, it's like the Charlie Brown. It's like, wah, 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 wah. People, people don't know.
Sure, I get it. I think a good place to go educate would be your YouTube channel. Did you have was there a link to that YouTube channel, or like the name of the YouTube channel that people could
Yeah,
go
so
to?
it's Liam Perlman, attorney at law. We have a new YouTube channel. We have a lot of videos, myths about bankruptcy, the difference between debt consolidation and Chapter 13, a lot of information about what happens when you buy a house after your credit. We've posted probably about 10 or 12 videos over the last month or so.
Nice, perfect. And how do people contact you? Anybody that's going to be seeing this, how would they reach out to you, one way or the
I
other?
lost your audio there.
How would people reach out to you? What would be your contact information? Oh,
Yeah, now I can hear you. You cut out. Yeah.
Your contact information, Lee. What would your contact information be?
Yeah, so I can be reached at New Jersey. I am L Perlman, so LPERLMAN. There's no A in my name, at New Jersey, which is spelled out, and then bankruptcy spelled out.com.
Perfect. All right, Lee, I appreciate it, and thank you for your time.
Thanks for having me, and I really appreciate it. Thanks again.
I'm sorry. I threw out something about this fresh start.
Okay. Go ahead, Ron.
Yeah, this fresh start thing after bankruptcy seems to be a myth. When people go through bankruptcy and after they got through Chapter 7, the fresh start is not as easy as the bankruptcy attorneys actually tell you after you do a bankruptcy. So, what is I think it's a myth. I don't think it's as easy as everybody thinks it is. After you come out of bankruptcy, do a fresh start, a fresh, a new beginning. It isn't. It doesn't exist.
Well, look, I think it depends on the client's situation. I think there's certain strategies that you can take. Sometimes bankruptcy lawyers explain what those strategies are. Many involve getting credit reports from TransUnion, Experian, Equifax, and looking at how payments or how trade lines are being reported, secured credit cards. There are a number of things. And I think the alternative is, what was the credit like before they filed? But many of my clients, we have some programs in place. Their scores are 750, 6 months post-discharge in many cases. Feel free to read my Google reviews. We have about 500 of them. Most of them are pretty happy what their situation looks like post-discharge. But obviously, it depends on your situation and what your credit looked like prior to filing.
What I'm finding is that the credit reports continuously reflect the bankruptcy, which really impacts you going forward with reestablishing credit. It doesn't come off. It sticks there for 7 years, I guess. And I don't know if I guess it says 7 years. And it just is a hindrance for going forward with other objectives of establishing better credit cards and all that.
Yeah. Well, listen, feel free to give me a ring, and I can maybe give you some direction and guidance to help you with that challenge.
Thanks, Lee.
Well,
Appreciate it. And anybody else that needs Lee's contact information as well, I put his email address in the chat, so you can also reach out to Lee. And okay, thanks, guys. Everybody have a great night.
You too. Bye-bye.
Bye.